Hello, and welcome back to thelegacylawyer.com. One question I get from people who've been designated as successor trustees to another person's trust or to their parents' trust is, how am I going to get compensated for the risk and the time that I spend as trustee of this trust? Oftentimes, the trust itself won't provide that information. It won't say how much the person should be compensated for their time, although sometimes it will. Sometimes a trust preparer can help the settlors designate how much the trustee should be compensated. It could be a percentage of the trust, or it could be a flat rate on a monthly, bi-monthly, or even weekly fee schedule. But more often, there is no designation. And unless the trust requires that the trustee waive their compensation, they are entitled to reasonable compensation. Now, what is reasonable compensation? If a beneficiary requests a review of a trustee's compensation, the court will look to several factors to see whether the compensation that the trustee asked for was reasonable. And here are some of the factors that the court looks at. First of all, amount of time spent. Was this a complicated trust? Was this a trust that required a lot of babysitting and hand-holding, a trust that required a lot of work on the part of the trustee? Or was this a small trust, mostly by the book? Secondly, the gross income of the trust. In other words, how much did the trust earn over the time that the trustee was managing it? This is a better guideline for the court than the size of the trust, because a trust can be very large but not producing a lot of income. Therefore, the trustee did not have to do a lot of extra work for it. Third, appreciation of the trust property. While the trustee was managing the trust, did the trustee grow and appreciate in value? This can be, to some extent, due to the trustee's actions, and therefore should be weighed in valuing the trustee's compensation. Next, did the trustee bring any unusual or special skills? In addition to being trustee, are they also an attorney? Are they an accountant? Are they themselves a private fiduciary? Do they have skills that came to value in their actions as trustee? Next, the level of loyalty or disloyalty to the trust. Did the trustee pass over opportunities because they would be disloyal to the trust if they took them? Or conversely, did the trustee act in such a way that put his interests at odds with those of the trust and the trust beneficiaries? Next, what are the typical fees charged by fiduciaries in the region in which this trust is being administered? So if this trust is being administered in San Diego County in California, the court can look to trust fees for other trusts being charged by private fiduciaries or public fiduciaries. Next, the character of the trust work. Was this a trust which required the trustee to be actively involved in making decisions, or was it more ministerial? And did the trustee rely on outside persons such as CPAs, attorneys, etc., to make financial and other decisions? Finally, the court will look to the trustee's own estimation of the value of their services, because they have a say in what they feel they should be charging. It's not going to get as much weight as some of the other factors, but it is a factor. And the court will listen to what the trustee has to say on that issue. Now, these factors come into play when there is an issue as to compensation. In other words, the trustee will designate an amount that he or she is charging, and that will come to light in an accounting to a beneficiary. And then the beneficiary will have to decide, is this value in the range, or is this something that I should have the court take a look at? Is it worth my time, my hiring an attorney, and my paying attorney's fees and court fees to have a court review this charge? That's typically how it plays out. And if you want to know more information, contact your local estate planning attorney. Thank you.